I think. I'll check, but we should be live.
Cool.
I didn't get any note. Oh, I just got a
Yeah,
notification.
I got
Cool.
one from Twitch.
And then and then it looks like we're on YouTube too.
Cool.
So, welcome, everyone. We are going to be listening we're going to continue listening to the Gonzalez versus Google LLC Supreme Court hearing. And we already listened to like an hour of it, a little bit over an hour of it yesterday. So if you're just joining us now, we're going to be starting at an hour and 10. So I just want to make sure. But I'm going to start it and then just let me know. You can hear that? Okay.
Okay.
Choices. So in every case in which there is content, there's also a choice about presentation and prioritization. And the whole point of suits like this is that those choices about presentation and prioritization amplify certain messages and thus create more harm. Now, I appreciate what you're saying is like, well, that doesn't mean that you're going to have. I appreciate what you're saying is like, well, but still, I mean, you are creating a world. You also have presentation
hire employees. But Ms. Black acknowledges in the brief that
Well, now I can't hear it.
be shielded by 230C1
No, you can
if
though.
there was an
Yeah.
allegation of unlawful discrimination, for instance. So the fact that the platform has to make some sorts of organizational choices doesn't mean it's immune from suit in the rare instance where it might make a choice that violates.
Hold on. So just on the, I wonder, hold on, I'm gonna try. Because for some reason, you can't see the, like the actual picture. Like it's just a blank see-through big square.
Oh,
Like
that's weird.
on the stream, you can't see the image, which is very weird. But what I'm just gonna try right now is, so we're gonna try that, and then we'll
Doesn't mean that you're
see if that shows up, and then we'll just have three of us.
Mhm.
Well, they're a little friend, but I just need to figure out. Okay. Otherwise, I don't know. I'll keep playing it.
Some other provision of law. The second thing is that the concern we have in mind are things like, imagine a hypothetical job matching service, like Indeed, where job applicants can post their qualifications and potential employers can post their own listings and the website will match them up. And suppose it came to light that the job search mechanism was routing the high-paying, more professional jobs disproportionately to the white applicants and the lower-paying jobs to the black applicants, even when the qualifications were the same. At a general level, you could describe that as choices about which content would go to which users. But when we saw that kind of stark impropriety in the criteria that the platform was using, I think we'd say there has to be, assuming it violates applicable law, 230C1 really shouldn't be protecting that. That's not, the complaint we have here is not to the content itself or the presence of the third-party job postings on the platform. The complaint is about the use of illicit criteria to decide which users will get which content. And our point is, in the more innocuous cases or in the borderline cases where the criteria seem a little bit shaky, but it's not clear whether they violate any applicable law, that choice ought to be made based on the law that the plaintiff invokes as the cause of action. And the court ought to be determining, does the use of those criteria violate that law?
I was just going to say, the problem with your analogies is that they involve, I don't know how many employment decisions are made in the country every day. But I know that, whatever it is, hundreds of millions, billions of responses to inquiries on the internet are made every day. And as Justice Kagan suggested, under your view, every one of those would be a possibility of a lawsuit if they thought there was something that the algorithm referred that was defamatory, that, whatever it is, exposed them to harmful information. And so that maybe the analogy doesn't fit the particular context.
I mean, I think it is true that many platforms today are making an enormous number of these choices. And if Congress thinks that circumstances have changed in such a way that amendments to the statute are warranted because things that didn't exist or that weren't on people's minds in 1996 have taken on greater prominence, that would be a choice for Congress to make.
Well, but choice for Congress to make. I mean, the amici suggests that if we wait for Congress to make that choice, the internet will be sunk. And so maybe that's not as a persuasive a outcome as it might seem in other cases.
I think the main thing I would say is most of the amici that are making that projection are making it based on a misunderstanding of our position. Namely, they are misunderstanding our position to be that once YouTube recommends a video or once YouTube sends a video to a particular user without the user requesting it, that YouTube is liable for any impropriety in the content of the video itself. And that's not our position. Our position is that YouTube's own conduct falls outside of 230C1. It's unlikely in very many instances to give rise to actual liability.
Why not? Why wouldn't it be liable? Explain that.
I think the reason we would say is for in this case in particular, to look ahead a little bit to the Twitter argument tomorrow. There were questions at the beginning of Mr. Schnapper's presentation about the role that neutrality played in the analysis. And our view is neutrality is not part of the 230C1 analysis, but it's a big part of the Anti-Terrorism Act analysis, because we say a person is much more likely to be liable for aiding and abetting if it is kind of giving special treatment to the primary wrongdoing, if it is taken. And so if it is in fact the case that YouTube is applying neutral algorithms, is simply showing more ISIS videos to people who've shown an interest in ISIS, just as it does more cat videos to people who've shown an interest in cats, that's much less likely to give rise to liability under the anti-terrorism.
Much less likely. I'm not sure based on what.
Yes.
So they're saying that the platform is neutral if it like only recommends videos of a specific subject, but like he's not really taking related subjects into account. Like if I was looking up, say, like calzones, how to make calzones, and then it gives me a recommendation for a pizza recipe, like that's not a calzone, it's a pizza, but it's related still. Like it's still relevant. And he's suggesting that, like, if they're recommending anything outside of the topic of the video you're watching, then that's not a neutral algorithm. But I think it can be neutral in cases where there's still related content that may not be the exact same subject.
Yeah, I would say so. Because I guess what was his... Did he give an example? I'm just going to scroll back up here. Because they stated YouTube is applying more ISIS videos. Or was it up below? So he's claiming that the algorithm isn't neutral, though. That's his claim. Oops.
Right.
Okay.
Because it was recommending ISIS videos when, like, this dude wasn't looking at ISIS videos. And I'm not saying YouTube should be able to get away with, like, platforming, ISIS, because that's not necessarily good. Like, if they're doing stuff that is illegal or against terms of service, at least, in the videos.
Yeah. Ready to keep.
Oh, yeah, go ahead.
Okay. I guess, yeah, I don't have much to say yet. I got to hear more of what. I need to hear a little more.
Seem to be putting a lot of stock on the liability piece of this rather than, as Justice Jackson was saying, the immunity piece. And I'm just not sure, if we go down this road, I'm not sure that's going to really pan out. Certainly, as Justice Kagan says, lawsuits will be nonstop on defamatory material, which there's a lot of, that is out there and finds its way onto the websites that host third-party conduct. There'll be lots of lawsuits. You agree with that?
wouldn't necessarily agree with there would be lots of lawsuits simply because there are a lot of things to sue about, but they would not be suits that have much likelihood of prevailing, especially if the court makes clear that even after there's a recommendation, the website still can't be treated as the publisher or speaker of the underlying third-party content.
Just bigger picture then to the Chief's question, isn't it better to keep it the way it is for us and Congress, to put the burden on Congress to change that, and they can consider the implications and make these predictive judgments? You're asking us right now to make a very precise predictive judgment that, don't worry about, it's really not going to be that bad. I don't know that that's at all the case, and I don't know how we can assess that in any meaningful way.
I think with respect that characterization of the existing case law overstates the extent to which courts are in agreement that platform design choices.
Assume they are, assume the status quo is against you in the law. And you're asking us, well, the status quo is wrong, okay? And this court's the first time we're getting to a look at it. But don't worry about the implications of this, because it's really all going to be fine. There won't be many successful lawsuits. There won't be really many lawsuits at all. And I don't know how we can make that assessment.
I think if the court thought that kind of the interpretive question, looking at the plain language of the statute, was on a knife's edge, it was an authentically close call, then yes, the court could, and the court perceived the existing case law to be basically uniform. The court could give some weight to the interest in stability, but I think for us, neither of those things is true.
Sorry, please finish.
I was going to say that the statutory text really is not, it may have a little bit of ambiguity at the margins, but it is very clearly focused on protecting the platform from liability for information provided by another information content provider, not by the platform's own choices. I'm sorry, Justice Barrett.
No, I'm sorry. So speaking of this question of what are the implications of this, and Justice Jackson's points about liability and immunity overlapping, it seems like one of the responses to should we worry about this is, well, it's going to be the rare kind of claim that could be based on recommendations. So speaking of that, what is the government's position, if you have one, on whether if the plaintiffs below lose tomorrow in Twitter, should we just send this back because there isn't? I mean, you said the government's position is that there is no claim.
Certainly our position, we haven't analyzed the Gonzalez complaint in detail, but that is our position as to the Twitter complaint, and Mr. Schnapper said he doesn't perceive a material difference between the two. Now, presumably the court granted cert in both cases because it thought it would at least be helpful to clarify the law, both as to the Anti-Terrorism Act and as to Section 230C1. But if the court no longer believes that, or if it resolves Twitter in such a way that it seems evident that its decision on the 230C1 issue wouldn't ultimately be outcome determinative in Gonzalez, then it could vacate and remand for further analysis of the ATA question. That would be a possible course of action.
Okay.
Thank you, counsel. We're talking about the prospect of significant liability and litigation, and up to this point, people have focused on the ATA because that's the one point that's at issue here. But I suspect there would be many, many times more defamation suits, discrimination suits, as some of the discussion has been this morning, infliction of emotional distress, antitrust actions. I mean, I guess I'd be interested to understand exactly what the government's position is on the scope of the actions that could be brought and whether or not we ought to be. I mean, it seemed to me that the terrorism support thing would be just a tiny bit of all the other stuff. And why shouldn't we be concerned about that?
Let me just address the potential causes of action that you mentioned. For defamation, even if somebody is suing about the recommendation, 230C1 still directs that the platform can't be treated as the publisher or speaker of the underlying content. And so the question—
Oh, right, but it's defamation law is implicated if you repeat libel, even though you didn't originally commit defamation.
If you repeat it, and so if YouTube circulated videos with a little blurb saying, and I think one of the amicus briefs describes this hypothetical scenario, if you repeated it with a little blurb saying, this video shows that John Smith is a murderer, then yes, there would be liability. But,
But there wouldn't be if you just repeated it without any commentary. Normally it would be if you're the newspaper and you just publish something, so-and-so's a shoplifter, the newspaper would be liable for that.
No, we think it should be analyzed as though it were an explicit recommendation. And so if Google had posted a message that said, we recommend that you watch this video. Now, the recommendation would be its own content. But in answering the question, can it be held liable for defamation, you would ask, can a person under the law of the relevant state be held liable for recommending content that is itself defamatory if the recommender does not repeat the defamatory aspects of that content in the course of the recommendation? And our understanding is that at least under the common law, the answer to that would be no, that simply saying you should read this book that turns out to be defamatory would not be a basis for defamation liability. I think the same would basically be true of intentional infliction of emotional distress. That is, unless you could show that the platform was acting with the intent to cause emotional distress by circulating the video, there would be no liability. And the fact that the third-party poster may have met the elements of that offense wouldn't carry the day. With respect to antitrust, if you had a claim that a particular search engine had configured its results in such a way as to boost its own products or to diminish the search results for products of the competitor, and if that were found to be a viable claim under the antitrust laws, there would be no reason to insulate the provider from liability for that.
Now, that's a broad overview of a lot of different areas of law, but certainly the law is not established the way you're suggesting, I think, in any of those areas.
But I guess the question is, what did Congress intend to do, or what did it do when it passed this statute? And Congress didn't create anything that was even resembled an all purposes of immunity for anything it might do in the course of its functions. It focused very precisely on information provided by another information content provider.
Thank you. Thank you. Justice Thomas? Justice Alito?
In the government's view, are there any circumstances in which an internet service provider could be sued for defamatory content in a video that it provides? I think third-party video.
I think the only, given our understanding of the common law, I think the only way that would happen is if the third-party provider, in circulating the video, added its own comment that incorporated the defamatory gist of the allegations. And as the Chief Justice was pointing out, it is true that under common law, if you repeat somebody else's defamatory statement, but say what it is, that you can be held liable for that.
I mean, imagine the most terribly defamatory videos. So suppose the competitor of a restaurant posts a video saying that this rival restaurant suffers from all sorts of health problems. It creates a fake video showing rats running around in the kitchen. It says that the chef has some highly communicable disease and so forth. And YouTube knows that this is defamatory, knows it's completely false, and yet refuses to take it down. They could not be civilly liable for that.
That's our, I mean, we think that Zeron was not exactly a defamation case, but it fit pretty closely within that profile. That is, Zeron was the early Fourth Circuit case in which a person posted a video that purported to be from another person and subjected to that other person to complaints and harassment that seemed justified to the people who were doing it.
Well, did any entity have that scope of protection under common law?
No, I don't believe so. And that was the point of C1. The point of C1 was to say,
well, it was at least to shield internet service providers from liability, based on their status as a publisher.
I wouldn't put it as,
even a distributor wouldn't have immunity if it knew, as a matter of fact, that this material that it was distributing was defamatory. Isn't that right?
I mean, that is right. I think we would think of the distributor as a subcategory of publisher, but yes, the bookseller would not be strictly liable. And obviously, Justice,
You really think that Congress meant to go that far?
we do, but obviously that is, if we're arguing about whether the failure to take something down is actionable, if it is done knowingly and with an understanding of the contents, then that's a very different argument from the one that we've been having up to this point. That would be saying that the statute should be
But that is your position.
Our
that is the
position,
government's position.
Our position, yes, our position is that if the wrong alleged is simply the failure to block or remove the third-party content, that 230C1 protects the platform from liability for that, whether it's based on a strict liability theory or on a theory of negligence or unreasonableness in failing to take the material down upon request.
The internet service provider really has it in for somebody, wants to harm this person as much as possible, and so posts extraordinarily gruesome videos of a family member who's been involved in an automobile accident or something like that.
Well, when you use the verb posts, that's a different analysis. That is, if YouTube creates...
No, it's provided by somebody else, and YouTube knows what it is, and yet it puts it up and refuses to take it down.
Yes, our view is if the only wrong alleged is the failure to block or remove, that would be protected by 230C1. But that's, the 230C1 protection doesn't go beyond that. And the theory of protecting the website from that was that the wrong is essentially done by the person who makes the post. The website at most allows the harm to continue. And what we're talking about when we're talking about the website's own choices are affirmative acts by the website, not simply allowing third-party material to stay on the platform.
So an express recommendation would potentially subject YouTube to civil liability. So they put up, they say, watch this ISIS video, spectacular. Okay, they could be liable there.
Yes, if the other elements...
It's express. What if it's just implicit? What if it's the fact that they put this up first and therefore amplify the message of that?
Again, you would have to ask, they could potentially be held liable for that, but you would have to ask whether the elements of the relevant tort have been shown. And with respect to the ATA, those elements include scienter, the causation of the relevant harm, et cetera. If you were looking at another cause of action, you would look at those elements. And I think part of our reason for preferring that most of the work be done at the liability stage rather than the 230C1 stage is, rather than do a kind of undirected inquiry into whether this seems neutral enough, you would be looking at a specific cause of action and asking, but for 230C1, would this be an actionable tort
under... Let me just make sure I understand this. Let's talk about defamation and an explicit recommendation. Go watch this video. It's the greatest of all time, okay? But it does not repeat anything about the video. It just says, go watch this video. It's the greatest of all time. And the video is terribly defamatory in the way Justice Alito was describing. Now, is the provider on the hook for that defamation?
The two things I would say are, that depends on the defamation law of the relevant state. And as we say in the brief, you should analyze that as though the platform was recommending in the same terms a video posted on another site. So if it would give rise to defamation liability under the law of the relevant state, to give that sort of glowing recommendation of content posted on a different platform, then there's no reason that YouTube should be off the hook by virtue of the fact that the material was on its own platform.
And now
Thank
it's...
you. Justice Sotomayor, anything further?
Let's assume we're looking for a line, because it's clear from our questions we are, okay? And let's assume that we're uncomfortable with a line that says merely recommending something without adornment. You suggest you might be interested in this, something neutral, not something like, they're right, watch this video. Because I could see someone possibly having a defamation action if I said, that video is right about that person. I could see someone saying that I'm spreading a defamatory statement, correct?
I mean, we don't understand the common law to have operated in that way, but obviously the laws vary from state to state, and a particular state could adopt a law to that effect.
How do we draw a line so we don't have to go past the complaint in every case?
I mean,
And I think that's where my colleagues seem to be suffering. And I understand your point, which is there is a line at which affirmative action by an internet provider should not get them protection under 230C, because that seems logical. The example I used earlier, the dating site, they create a search engine that discriminates. Their action is in creating the search engine, and I would think they would be liable for that. So tell me how we get there.
I guess whether they would be liable would depend on the applicable substantive law, which could be a federal law or could be a state law. And those questions obviously are routinely decided at the motion to dismiss stage. That is, with respect to the search engine choices that I described earlier, do you include misspellings or not? The plaintiff would still have to identify a law that was violated by the choice that the search engine made, and would have to allege facts sufficient to show a violation of law. And suits like that could easily be dismissed at the pleading stage. But it would at least predominantly be a question of the adequacy of the allegations under the underlying law.
Justice Kagan.
Because I thought that the claims in these kinds of suits are that in making the recommendation or in presenting something as first, so really prioritizing it, that the provider is amplifying the harm, is creating a kind of harm that wouldn't have existed had the provider made other choices. Are you saying that is something that could lead to liability, or is not?
I think it is something that could lead to liability, but again, you'd have to establish the elements of the substantive law. And so kind of the hypothetical we're concerned with, and the hypothetical that I think would come out what in our view is the wrong way under respondents' theory, is imagine a particular platform had been systematically promoting third-party ISIS videos, and promoting in the sense of putting them at the top of people's queues, not of adding their own messages, in order to enlist support for ISIS. If that was the motivation, and you could show the right causal link to a particular act of international terrorism, then that could give rise to liability under the ATA.
And you're not saying that the motivation matters for 230. You're saying that the motivation matters with respect to the liability question down the road, right?
Exactly.
Justice Gorsuch?
Mr. Stewart, I just, again, kind of want to make sure I understand your argument. And so I'm going to ask you a question similar to I asked Mr. Schnapper, which is, the Ninth Circuit held that any information a company provides using neutral tools is protected under 230. That's at 34A of the petition. And your argument is that this neutral tools test isn't in the statute. What is in the statute is a distinction, on the one hand, between interactive computer service and access software providers, and on the other hand, content providers. And when we look at that, the access software provider is protected for picking, choosing, analyzing, or even digesting content. So 230 protects an access software provider or an interactive computer service provider who does any of those things, whether using a neutral tool or not. They can order, they can pick, they can choose, they can analyze, they can digest, however they wish, and they're protected, even though those editorial functions we might well think of as some form of content in our First Amendment jurisprudence, but here they're shielded by 230. And then your argument, I think, goes that none of that means that they're protected for content generated beyond those functions. And it doesn't matter whether that content is generated by neutral rules or not. That content is actionable. And one can think of content generated by neutral rules, for example, by artificial intelligence. And another problem also is that it begs the question what a neutral rule is. Is an algorithm always neutral? Don't many of them seek to profit maximize or promote their own products? Some might even prefer one point of view over another. And because the Ninth Circuit applied the wrong test, this neutral tools test rather than the content test, we should remand the case for reconsideration under the appropriate standard. Is that a fair summary of your position? And if not, what am I missing?
I think the aspect of that we would disagree with is we don't think that the definition of access software provider means that an entity is immune from liability for performing all of those functions. The statute makes clear that even if you perform those sorting, arranging, et cetera, functions, you still fall within the definition of interactive computer service, and you are still entitled to the protection of C1. But the protection of C1 is protection from liability for the third-party content. And so if you perform those sorting functions in a way that was otherwise unlawful, you could be on the hook for that. And that takes me back to the hypothetical about the job placement service that discriminates based on race. The allegation of that job placement service is not that it created any of its own content. The allegation would be that with respect to third-party content provided by the firms that were looking for employees, it had used an legally impermissible criterion to decide which content would be sent to which users. And that wouldn't be protected by C1 because imposing liability wouldn't hold the platform, wouldn't treat the platform as the publisher or speaker of the third-party content.
Thank you.
Justice Kavanaugh?
First, to follow up on Justice Alito's question, the distributor liability question, my understanding is that issue is not before us at this time.
That's correct.
And your position, though, or your response to him suggested that if we were addressing that, the reason that falls within 230 is because the distributor at common law, or at least by 1996, was treated as a secondary publisher in the circumstances described there. Is that?
That's basically correct.
Okay. Then focusing on the text of the statute and following up on Justice Gorsuch's question, it seems to me that the key move in your position, as I understand it, is to treat organization through the algorithms as the same thing as an express recommendation. Is that accurate?
I don't think we would put it quite that way. That is, in some instances, if the operation of the algorithm causes particular content to appear in a particular person's queue that the person hadn't requested, then that person might perceive it to be a recommendation, at least to the effect that you will like this based on what you have seen before. So algorithms can't have that effect. I don't know that we would equate the two. I think we would say more the recommendation is simply one instance of the platform potentially being held liable for its own content rather than the third-party content.
And if the algorithm prioritizes certain content, that becomes the platform's own speech under your theory of 231, correct?
I don't know that we would call it the platform's own speech, but it's the platform's own conduct, the platform's own choice. And so if it violated antitrust law, for instance, to prioritize search results in a particular way, whether or not you thought of that as speech by the platform, it would be the platform's own conduct. Holding it liable for that sort of ordering wouldn't be treating it as the publisher or speaker of any of the third-party submissions.
So the other side and the amici say that happened. That's with and Justice Kagan's question. That's happening everywhere, and therefore 230 really becomes somewhat meaningless. And you've read what makes the definition of interactive computer service, including organizing, to be a self-defeating provision that really does nothing at all.
No, I think if it is happening everywhere, that is, if search engines are using a wide variety of mechanisms to decide how content should be ordered,
Do you disagree with that? I mean, that's
I agree with that, but I think
Okay.
that's probably because there are very few, if any, laws out there that direct internet service providers to order the content in a particular way. If a particular legislature wanted to say it will now be a violation of our law to give greater priority to search results of companies that I advertise with you, then the question whether that could violate the Commerce Clause, the question whether it could violate the First Amendment, those would be live questions. They wouldn't be 230C1 questions because the state's attempt to impose liability on that rationale would not be an attempt to hold the platform liable as the publisher or speaker of the third-party content.
Justice Barrett?
I want
Okay,
to ask
pause.
you the question that Mr.
Yes.
Schnapper and I went back and forth about
Hold
thumbnails
on.
versus.
There we go.
I just need to use the bathroom.
Oh, okay. I'm gonna do then. We'll be back. Okay. You ready? Can you hear me?
I was muted. My bad.
Oh, okay.
Yeah,
No, you're
I can
good.
hear you.
Okay.
Where are we at time-wise on it?
We're at,
Oh God, we still got another hour.
yes. Okay.
So screenshots, what would the government's position on that be? So if there were screenshots on the side, his objection seemed to be that it was Google's content because YouTube creates these thumbnails.
And that was one aspect of Mr. Schnapper's theory that we disagreed with in the brief. That is, we thought that it's basically the same content, the same information either way, even if in the one instance Google is creating a URL and in the other instance it's not.
So for purposes of this case, is there any difference? Let's imagine that the Google algorithm, when you search for ISIS, prioritizes videos produced by ISIS in search results. I'm not talking about being on YouTube. Content produced by ISIS, as opposed to articles. If you're just looking for articles about ISIS, they could be critical of ISIS. They could be all kinds of things. But in the search result rankings, you first get the articles written by ISIS, videos made by ISIS. Is that the same thing as this case then?
I think that would be the same thing as this case, because we would say the fact that the videos appear in that order is the result of choices made by the platform, not the choice of any person who posted an ISIS video on the platform. And Congress, it was very important to Congress to absolve the platforms of liability for the third-party content, but it didn't try to go beyond that. The likelihood that ISIS would be held liable just for that seems very, very slim, but it would not be a 230C1 question. It would be a question under whatever cause of action the plaintiff invoked.
Okay, and then what about users and retweets and likes? The question I asked Mr. Schnapper about that. So, I gather 230C would protect me from liability if I simply retweeted on Ms. Blatt's theory, on your theory. If I retweet it, am I doing something different than pointing to third-party content?
I think honestly there hasn't been a lot of litigation over the user prong of it, and those are difficult issues. I think 230C1 at the very least would say, just by virtue of having retweeted, you can't be treated as though you had made the original post yourself. But with respect to you retweet, can the retweet itself be grounds for liability? I'm not sure, and I doubt that there would be much of a common law history to draw upon.
So, but the logic of your position, I think, is that retweets or likes or check this out for users, the logic of your position would be that 230 would not protect in that situation either, correct?
I think it would, I think more or less the case. The one difference I would point to between the user and the platform is the user who reads a tweet is typically making an individualized choice. Do I want to like this tweet, retweet it, or neither? Whereas the platform decisions about which video should wind up in my queue at a particular point in time, there's no live human being making that choice on an individualized basis. It's being that those choices are being made on a systemic basis.
Justice Jackson?
Yeah, so can you help me to understand whether there really is a difference between the recommendations and what you say is core 230 conduct? I mean, I get, and I'm holding firm in my mind, that 230 immunity, Congress intended it to be directed to certain conduct by the platform, and that conduct is its failure to block or screen the offensive conduct. So that if the claim is this offensive content is on your website and you didn't block or screen it, 230 says you're immune. I get that. I guess what I'm trying to understand is whether you say, and plaintiff says, petitioner in this case says, well, what they're really doing in the situation in which they display it under a banner that says up next is more than just providing that content and failing to block it. They are promoting it in some way. And I'm really drilling down on whether or not there is actually a distinction in a world of the internet where, as Ms. Blatt and others have said, in order to be a platform, what you're doing is you have an algorithm, and in the universe of things that exist, you are presenting it to people so that they can read it. Why is that, even though it's, you call it a recommendation or whatever, why is that act any different than being a publisher who has this information and hasn't taken it down?
I mean, I think I would say in the situation that 230C1 was designed to address, the decision whether the material would go up on the platform was not that of the platform itself. It was the decision of the third-party poster. And Congress said, once that has happened, you also can't be held liable for failing to take it down. But with respect to what prominence you give it, that's the result of your own choice, not the third-party poster. Now, in most circumstances, it won't make a difference because the recommendation won't be actionable. And so what we are concerned with is the hypothetical that I suggested earlier.
I get that. I get the liability piece, and all of the parade of horribles will depend on whether or not they can actually be held liable for organizing it in a certain way. And you say they probably can't, and others say they might be able to, and that's a separate issue. Just back on the 230 piece of it, in terms of Congress's intent with respect to the scope of immunity, I guess I just want to understand why Google or YouTube, when they have a box that brings up all of the ISIS videos and tees them up, and if you don't do anything, they just keep playing, why that's actually different than the newspaper publisher who gets the offensive content and decides to put it on page 1 versus page 20. It seemed like Congress in 230 was saying if under the common law, a newspaper publisher would be liable for having put it on page 1 or whatever and given it to people, we don't want that to be the case for these internet service companies. And so I don't know that I understand fully why the fact that that you call it a recommendation or whatever is actually any different.
I guess one difference I would point to is newspaper publishers can make decisions about what will be on the front page and what will be in the back, but it's going to be the same for everybody. And one of the things about why we call them targeted recommendations with YouTube is they are being sent differently to different users. And the situation we're concerned with is, what if a platform is able through its algorithms to identify users who are likely to be especially receptive to ISIS's message? And what if it systematically attempts to radicalize them by sending more and more extreme ISIS videos? Is that the sort of behavior that implicates either the text or the purposes of Section 230C1? And we would say that it doesn't.
Thank you.
Thank you, counsel.
Thank you.
Ms. Blatt?
Mr. Chief Justice, and may it please the court. Section 230C1's 26 words created today's internet. C1 forbids treating websites as, quote, the publisher or speaker of any information provided by another. Publication means communicating information. So when websites communicate third-party information and the plaintiff's harm flows from that information, C1 bars the claim. The other side agrees Section 230 bars any claim that YouTube aided and abetted ISIS by broadcasting ISIS videos. So they instead focus on YouTube's organization of videos based on what's known about viewers, what they call targeted recommendations. They say that feature can be separated out because it implicitly conveys what viewers should watch or that they might like the content. But accepting that theory would let plaintiffs always plead around C1. All publishing requires organization and inherently conveys that same implicit message. Plaintiffs should not be able to circumvent C1 by pointing to features inherent in all publishing. C1 reflects Congress's choice to shield websites for publishing other people's speech, even if they intentionally publish other people's harmful speech. Congress made that choice to stop lawsuits from stifling the internet in its infancy. The result has been revolutionary. Innovators opened up new frontiers for the world to share infinite information. And websites necessarily pick, choose, and organize what third-party information users see first. Helping users find the proverbial needle in the haystack is an existential necessity on the internet. Search engines thus tailor what users see based on what's known about users. So does Amazon, TripAdvisor, Wikipedia, Yelp, Zillow, and countless video, music, news, job finding, social media, and dating websites. Exposing websites to liability for implicitly recommending third-party content defies the text and threatens today's internet. I welcome your question.
Ms. Blatt, could you give me an example of not a recommendation, but an endorsement similar to this that would take you beyond 230?
Sure. So whenever you have something that's going beyond the implicit features of publishing and you have an express statement, you have a continuum. And this continuum is this. You have something that's the functional equivalent of an implicit message, basically a topic heading or up next, all the way to the other extreme of an endorsement of the content, such that the website is adopting the content as its own. Now, when you have that situation, the claim is fairly treating the website for publishing its own speech, and you can separate that out from the harm that's just coming from the information provided by another. And the danger which your hypotheticals has raised with express speech is where on that continuum any express speech may go. Because unlike Google and YouTube, which are the two world's largest sites, we don't have a lot of endorsements and that kind of stuff. But other websites and other users use a myriad of topic headings and emojis that have different meanings that I'm not prepared, and you would have to know what they mean, like kinds of check marks and high fives and all kinds of things. But the basic features of topic headings, up next, trending now, those kinds of things we would say are core inherent. They're no different than expressing what is implicit in any publishing, which is, we hope you read this.
Well, it seems to me that the language of the statute doesn't go that far. It says that their claim is limited, as I understand it, to the recommendations themselves. In other words, this is the list of things that you might like. But that information, the recommendation, is not provided under the words of the statute. It's not provided by another information content provider. It's provided by YouTube or Google. And so, although whatever the liability issue may be, there's some issue tomorrow, we'll talk, there are a lot of others, the presence of an immunity under 230C, it seems to me, is just not directly applicable.
Well, that's incorrect because of the word recommendation. There is no word called recommendation on YouTube's website. It is videos that are posted by third parties. That is solely information provided by another. You could say any posting is a recommendation. Anytime anyone publishes something, you could be said it's a recommendation.
The videos just don't appear out of thin air. They appear pursuant to the algorithms that your clients have, and those algorithms must be targeted to something. And that targeting, I think, is fairly called a recommendation, and that is Google's. That's not the provider of the underlying information.
So nothing in the statute or in the common law of defamation turns on the degree of tailoring or how you organized it. There's no distinct actionable message. If you say, I think my readers would all be interested in this, or I think the readers in zip code 2005 would be interested in it, or if you walk up to someone and say, I'm going to defame someone because I thought you might be interested in it, it's still publishing. And the other side gives you no line and no way to say in some way that would be workable or give websites or users any clarity of how you would organize the world's information. Just think about search. There are 3.5 billion searches per day. All of those are displays of other people's information, and you could call all of them a recommendation that are tailored to the user, because all search engines take user information into account. They take the location, the language, and what have you. And I can give the example of football. Football, the same two users will enter the word football and get radically different results based on the user's past search history and their location and their language, because most of the world thinks of football as soccer, not the way we do. And so if you go down this road of, did you target it? Then you have to say how much. Was the topic hitting too much? Was it okay to have a violence channel? Was it okay to have a sex channel? Was it okay to have, what have you, some other channel about skinny models that you could say, well, that just kept repeating the channel and that made me crazy. So,
but Ms. Blatt, Mr. Stewart suggests that all of those kinds of questions in terms of the extent of liability for this kind of organization would be addressed in the context of liability. Not, by that I mean each state, when somebody tried to claim that YouTube had done something improper in terms of pulling up those kinds of videos, that each state would then look and determine based on their own, common law, whether or not you were liable. And he posits that that wouldn't happen very often, but we don't know. My question is, isn't there something different to what Congress was trying to do with 230? Isn't it true that that statute had a more narrow scope of immunity than courts have, ultimately interpreted it to have, and that what YouTube is arguing here today, and that it really was just about making sure that your platform and other platforms weren't disincentivized to block and screen and remove offensive content. And so to the extent that the question today is, well, can we be sued for making recommendations? That's just not something the statute was directed to.
So can I take this in two parts? Because I feel like your first part of your question is addressing what the dispute is between the parties, and the second part of your question goes much deeper, and which is, beyond the question presented. But just on your first question about why do you need an immunity as opposed to liability? And in our view, that's like saying, that's death by 1,000 cuts, and the internet would have never gotten off the ground if anybody could sue every time, and it was left up to 50 states' negligence regime. And let me give you an example. A website could put something alphabetical in terms of reviews, and every Young, Williams, and Zimmerman, i.e. XYZ, could say, well, that was negligent because you should have rated it somewhere else.
No, I totally understand that, but I think my things are not actually different. What I'm saying is that problem that you identify, which is a real problem, the internet never would have gotten off the ground if everybody would have sued, was not what Congress was concerned about at the time it enacted this statute.
Well, so that's correct. That's incorrect for a number of reasons. And we can talk about what two choices you're talking about. There's only two arguments on the table for what you could think that C1 does. And that is, it simply says, no interactive computer service shall be treated as a publisher. And you could think, well, there's two ways of looking at that. One is that you need an external law that has publication as an element. And then second, which I think that your question may be going to, is it only directed to eliminating forms of strict liability across all causes of action? And so both of those ways are highly problematic and also inaccurate given what was happening in 1996. In terms of just looking at this as, is this just talking about defamation? It plainly can't be, because the statute would be a dead letter upon inception, because any defamation cause of action can be repled as negligence or intentional infliction of emotional distress. So we think the word treat, which means to regard, applies whenever the claim is treating or imposing liability because by virtue of publishing. In other words,
but what do you do with the title and the content and the context? Right? The title of Section 230 is Protection for Private Blocking and Screening of Offensive Material.
So let me just pinpoint then the second one, which hopefully we'll get to on Section E, which is all the exceptions. But in terms of the title, Stratton, Oakmont, and restrictions, C1 and C2 are a pair. So what you have is C2 and they work together. And every time you weaken C1, you make C2 useless and defeats the whole point of this statute, at least in terms of cleaning up the internet. C2 is just a safe harbor and directs what happens when you take stuff down. It says nothing about what happens to the content that's left up. And so the more any website removes material, it perversely is showing that it has knowledge or should have known or could have known about the content that was left up. And so you have one of two things happen that would happen and would have happened then and would happen now. The first is websites just won't take down content, and that just defeats it the whole point. And you basically have the internet of filth, violence, hate speech, and everything else that's not attractive. And the second thing, which I think a lot of the briefs are worried about in terms of free speech, is you have websites taking everything down and leaving up basically you take down anything that anyone might object to. And then you basically have, and I'm speaking figuratively and not literally, but you have the Truman Show versus a horror show. You have only anodyne, cartoon-like stuff that's very happy talk. And otherwise you just have garbage on the internet. And Congress would not have achieved its purpose and remember, it had in all those findings, only 3 of which are addressing the harmful content. Most of it is dealing with having free speech flourish on the internet, jumpstarting a new industry. And it's inconceivable that any website would have started one lawsuit freaked out the Congress.
Ms. Blatt?
Yes.
Suppose that this were a pro-ISIS algorithm. In other words, it was an algorithm that was designed to give people ISIS videos, even if they hadn't requested them or hadn't shown any interest in them. Still the same answer that a claim built on that would get 230 protection?
Yes, except for the way Justice Sotomayor raised it, which is material support. So if there's there's a criminal exception. So if you have material support in collusion with ISIS, that's accepted from the statute. But if I can just take the notion of algorithms, either they're raising.
But what I take you to be saying is that in general, and this goes back to Justice Thomas's very first question.
Yes.
In general, whether it's neutral or whether it's not neutral, whether it is designed to push a particular message, does not matter under the statute, and you get protection either way.
That's correct. And I'm just I agree with what Justice Gorsuch said, except for he was saying that somehow the Ninth Circuit was at fault because it recognized this was an easy case. It's not the Ninth Circuit's fault that the complaint said, there's nothing wrong with your algorithm. You just kept repeating the same information independent of any content. And so we shouldn't be faulted because his complaint doesn't allege anything wrongful. No. But in your hypothetical, where someone could say, and again, this is always going to turn on the claim, but let's just think of, I don't know what your hypothetical would be about tortious speech, but the bookstore example, you could decide that you want to put the adult book section separated from the kid section. That's a biased choice, and I'm doing scare quotes for the transcript.
Or how about an algorithm that looks for defamatory speech and puts it up top, right? And you're still saying 230 protection.
So our test, when you look at the claim, and so if you have a claim for defamation, is always going to look at the claim and say, is the harm flowing from the third-party information or from the website's own conduct or speech? And so if I can mention the race example, that's an excellent example of the claim has nothing to do with the content of the third-party information. It can be...
Right, but the claim would have something to do with the content of the information. It would say, my complaint is that you just made defamatory speech available to millions of people who otherwise would never have seen it. And you are on the hook for that. That was your choice. That's your responsibility. Why should there be protection for that?
Well, so if there's some sort of misrepresentation or some sort of terms of service that you weren't going to do that, but let me give you an example where this opens up a can of worms, is because you could say that about any content, that you elevated the most recent content. I mean, search engines and of all kinds, including Google search, but all the amici briefs are telling you they have to make choices. They've got an undescribable amount of content, and it has to be based on something, whether it's relevance to a user request, a search history. If it says headache, the Microsoft example, do you want something from the 1300s, or do you want something that's a little more recent?
Okay, but what if, I'm sorry, but I just want to make sure, in Justice Kagan's example, what if the criteria, the sorting mechanism was really defamatory? or pro-ISIS. I guess I don't see analytically why your argument wouldn't say, as Justice Kagan said, that, yeah, 230 applies to that.
Well, it's similar to your 303 case. You can make a distinction between content choices in terms of how you would organize or deal with any kind of publication, whether it's a book, a newspaper, a television channel, that kind of stuff. And that is inherent into all publishing.
Right, so you're saying 230 does apply to that. 230
Yes.
gives protection regardless.
Yes, I hope I didn't say something incorrect.
230 gives protection
Yes.
regardless, whether it's like put the defamatory stuff up top, put the pro-ISIS stuff on top, or whether it's, what people might consider a more content neutral principle.
Correct. And let me just say, you have websites that are hate speech. So they may be elevating more racist speech as opposed to some other speech that talks about how the equality of the races. You might have a speech devoted to, an interest of a certain community, like an ethnic community. So they may be saying, you know what, we don't want to put some other kind of content. We may want to publish it, but we may want to put it further down on our algorithm. And if you said, again, this is a content distinction. If you have a claim.
So I can't imagine that. And then, we're in a predicament here, right? Because this is a statute that was written at a different time when the internet was completely different. But the problem that the statute is trying to address is you're being held responsible for what is another person's defamatory remark. Now, in my example, you're not being held responsible for another person's defamatory remark. You're being held responsible for your choice in broadcasting that defamatory remark to millions and millions of people who wouldn't have seen it otherwise through this pro-defamatory algorithm. And the question is, should 230 really be taken to go that far?
The question is, can you carve out pro-defamatory as opposed to pro anything else, pro some other type of content that someone may be suing over negligence? If I can just give you an example of a TV channel. When you broadcast an excessively violent TV channel, you're giving it a new audience that they wouldn't otherwise have. It's still inherent to publishing. And if you decide to run reruns of the most sexually explicit and violently explicit, you could say that's a bad thing, and it may be, but on your choice, but it would be protected under 230. In terms of what was happening in 1996, I strongly disagree with the notion that algorithms weren't present based on targeted recommendations. The Center for Democracy and Technology has this wonderful history lesson of what was happening in 92 through 94 on how targeted recommendations developed. And you had something called news groups, which were, for anyone using the internet, that was sort of what people did. They signed up for a news group, and those news groups adopted the technology that is alleged in this case. They looked at what the user was looking at. Say the user was looking at science news, and they thought, oh, that also user is looking at some other kind of news, maybe on psychology or something. And so they would make recommendations based on your user history and that of others. Amazon, 2 months into 1997, introduced its famous feature of if you buy X, you might like Y, based on that technology. So this technology was present starting in 92. And 92 through 96, the internet was definitely different, but it was kind of a mess. You still had to organize it. So there were search engines, there was all kinds of features that were organizing content, because even then it was massive. It's just now on like an exponentially greater scale.
Ms. Black, I guess my concern is that your theory that 230 covers the scenario that Justice Kagan pointed out seems to bear no relationship, in my view, to the text of the actual statute.
Sure.
I mean, when we look at 230C, it says protection for Good Samaritan blocking and screening of offensive material, suggesting that Congress was really trying to protect those internet platforms that were in good faith blocking and screening offensive material. Yet, if we take Justice Kagan's example, you're saying the protection extends to internet platforms that are promoting offensive material. So it suggests to me that it is exactly the opposite of what Congress was trying to do in the statute.
Well, I think a lot of things are offensive that other people might think are entertaining.
No, it's not about whether, let's take as a given we're talking about offensive material, because that's all through this statute, right? You don't disagree that Congress was focused on offensive material, that's sort of the basis of the whole statutory scheme. So if we take as a given that we're talking about offensive material, it looks to me from the text of the statute that Congress is trying to immunize those platforms that are taking it down, that are doing things to try to clean up the internet. And in the hypothetical that was just presented, we have a platform that is not only not taking it down in the way that the statute is focused on, it is creating a separate algorithm that pushes to the front so that more people would see it than otherwise, the offensive material. So how is that even conceptually consistent with what it looks as though this statute is about?
Well, so just a couple things. And again, we're on this defamatory material. If the website itself does something defamatory it's independent of the third-party content, it's not protected. But that same hypothetical could be said if it was on the front, the home page, as opposed to you had to do a search engine first. And I don't see anything in the statute that protects it. In terms of what I think your deeper section is a deeper concern is the reading of the statute. I don't think it's coterminous with C2, which is dealing with the type of offensive material, which, by the way, doesn't mention defamation. In terms of C, we talked about how they work together. We talked about how it could be easily overrode if it had just publication. The one thing we didn't talk about was the structure in Section E. E is a laundry list of a variety of exceptions under federal law to which C1 does not apply, as well as C2. And those exceptions make very little sense if C1 is read the way you're reading it. It would almost never apply to C2. And let's just take federal criminal laws. It would make very little sense because those laws, almost none of them have strict liability as an element, and vanishingly few would have publication or speaking as an element. It's in there for no other reason other than that C1 would otherwise apply to the information provided by another. And in terms of just the pure text, when you keep saying it's failure to take down, I'm hearing you say what Congress wrote was treatment as a publisher. That means dissemination. That means publishing. You cannot be held liable for publishing.
If you look at the statute, it says protection for Good Samaritan blocking and screening. If you take into account Stratman, Oakmont, those things I thought were like a given. What the people who were crafting this statute were worried about was filth on the internet and the extent to which, because of that court case and perhaps others, the platforms were not being incentivized to take it down. Because if they were trying to take it down like Prodigy, they were going to be slammed because they were going to be treated as a publisher. And so the statute is like, we want you to take these things down. And so here's what we're going to do. We're going to say that just because they're on your website, it doesn't mean you're going to be held automatically liable for it. And that's C1. And to the extent you're in C2, you're trying to take it down, but you don't get them all, we're not going to hold you liable for it. That seems to me to be a very narrow scope of immunity that doesn't cover whether or not you are making recommendations or promoting or doing anything else.
Well, I mean, that is what I understand the government and the petitioner to be saying is that disseminating, even 24/7 disseminating of ISIS videos is protected. The only thing that's not protected is whether you can tease out something about the organization and call it a recommendation when there is no express speech recommending it. It's just the placement of where in the order in which content appears. And that same complaint could be made about search engines. So I think under your view, search engines would not be covered because they are taking user information, targeting recommendations in the sense of they're saying, we think you would be interested in the first content as opposed to the content on, 1,692 sections. I mean, they have millions and millions of hits for any search result. And if you think those are recommendations and the other side gives you no basis for distinguishing between search engines, then the statute is just very different than what I think the one that Congress was talking about. Because again, if you're going to look at findings and history and policy, this is about diversity of viewpoints, jumpstarting an industry, having information flourishing on the internet, and free speech.
I think I disagree with her, though.
Why?
Because basically it sounds like she is, like, I agree with the judges. I think that she's wrong. by trying to defend, because it's different. If I go to Google and search ISIS, then I am looking for it. But
Yeah.
if it pops up on recommended on a
Yeah.
YouTube video, I didn't search for that, but that popped up to me. That was
Right.
pushed to me from the algorithm.
Yeah. Okay.
So she's trying to say that it's comparable to a search engine, but I don't think it is, because if I'm searching for something, that's different.
Yeah.
And it depends on how the algorithm works. Like, is the video that it's being recommended on similar to ISIS, or is it completely, I guess that's kind of what you were saying earlier too, where
Yeah.
like cakes and muffins.
Yeah.
But if you're watching, like, I don't know, what's
Like if
a
you're
good,
watching a cooking video and then an ISIS video
yeah,
pops up as a recommendation
then
or
that's
something like,
concerning. But
yeah.
yet she is claiming that they would have immunity for that. But they also do have to be taking videos down. Like that is part of
Yeah.
C2, I think, is what they said.
Yeah. And I
Or
mean, I
it's
get they
part of
can't
the
take
2 or
every
3.
video down, but they gotta be
They have
better
to try,
about it. They
yeah, they
should
need
be
to be
able
better
to.
about it, though, with how,
Yeah, they need more people to review their stuff, or they need to create more. They need to create better algorithms that actually work and taking down
yes.
the right videos. Because I've heard some stories about people's videos getting taken down by algorithms, just and like they don't even have what they claim they had that got it taken down in the video.
I didn't even know algorithms could take down videos, but yeah, that's just, I don't know. That's just, I don't agree with this
But I don't
Google's
think it
defense.
means that. I mean, if they are going to get rid of this law, then like they need to have a plan to create new laws. They can't just
Yeah,
get rid
yeah.
of this law and then do nothing. So
And I
it's going to
think
destroy the internet.
that's kind of why they keep going. Like, I think that's what they were doing with the first people, is like, well, if we were to side with you, what would happen
Yeah.
in this scenario and in this
Right.
scenario, which is kind of why it was hard to sometimes keep track of, because they kept like jumping around to random, which seemed like random, but it makes sense because they want to make sure that if
Yeah.
we were to side with you and fault them,
Yeah.
which
But they
would
were very,
eventually make 230 kind of useless, then what is going to happen in all these other cases
yeah,
that are going to
they're
pop
very
up?
different examples, though.
They were, yeah. But I guess like
They did jump around between them. But
yeah.
I mean, I get why they brought them up, though.
Yeah, just to make, like, just in case, like, what, like, the whatever that's, what is that called again, when you have to think ahead in law?
Like preparing, or
No, there's like precedent, like,
oh,
well, I guess they wouldn't be setting a precedent, but they would be thinking of future cases that may set precedents if they were to take down this one or whatever. But
yeah,
so yeah, but yeah, and I mean, this lawyer seems more well spoken, but she's
I
also
agree.
paid for by a Google company, so
exactly.
she,
That's what I was thinking too, honestly.
because I think the other one is a family, isn't it? Like the Gonzalez.
Yeah, they're
so
like
they
the
probably don't
family
have
of
as much
somebody who got
money
killed
as
in the Paris
Google,
attack.
which I think that's ridiculous too. Everyone should be provided a good lawyer, regardless of money.
Right.
And I'm not saying the other lawyers aren't good. I'm just saying that this one seems way more like she probably had more time to prepare, and Google probably was able to fund her like a lot more and provide her way more resources, which is not fair.
Well, and better lawyers just charge more money too.
Yeah, they do. Yeah.
Because they
Which
can.
I also don't like, but that's
yeah, I
capitalism.
think all lawyers should be state appointed.
Oh yeah,
and there should be more state appointed lawyers to take care of all the cases.
Yeah, because otherwise that's not a fair system. I don't see how you can go around saying that you have to have money to have a good lawyer is the fair system.
Right.
Like, that's a capitalist system, sure, but that's not a fair system. I mean, capitalism itself isn't fair.
Right.
And everyone says that. Everyone goes around saying life isn't fair. Like, okay, but some things should be fair. I think law should be fair and just. So maybe law shouldn't be capitalistic, you know? Just maybe.
No,
That's
it
just
really shouldn't.
maybe. Just a thought. Oh, but okay. We'll keep going. We have 20 minutes left.
Oh, that's it?
the discrimination, like, oh, we're not gonna match black people and white people, et cetera. What about that? Is that given 230 shield?
Absolutely not, because any disparate treatment claim or race discrimination is saying you're treating people different regardless of the content. So if let me use it like with an advertising, like, I don't know, whether I'm a woman of 10 or, I mean, it was a bad example, a woman of 30 or whatever, and whether I live somewhere, it really doesn't matter in terms of the law that's prohibiting discrimination. The law is indifferent to what the content is. It's just very unhappy about any kind of status-based distinction. So we think, and the harm that would flow is not the third-party information, it's the website's conduct, whether you want to call it speech or conduct, that's based on status.
But what about the dating profile? I mean, isn't that part of the content? Isn't that part of the third-party information?
Sure, and it's just, you could put it a bunch of different ways. You could say even before the profiles go up, there's a complete harm, or even if the profiles go up, it doesn't matter. We would distinguish between the way dating sites work, which don't work based on status, but based on criteria that's uploaded. And those are, you're matching with somebody else. The website is not saying you should only date a white person.
Okay, then what about news? What about an algorithm that says, you are a white person, you're only going to be interested in news about white people, and I'll screen out anything that is a story featuring racial justice issues?
Yeah, again, anything based on status, because the harm is complete, independent of the information. But if a website wants to say we're going to celebrate Black History Month, no, a white person or a black person is not going to be able to complain and say, well, I didn't get enough White History Month on your website. Those are claims that are core within treating them as publishing of the information.
Yeah, but I guess then don't you think you're just fighting on liability? I mean, it seems to me that you're kind of going back to liability, because all of those are choices that are made independently, right? I mean, we've been talking about the distinction between, or the lack of distinction in your view, between the content itself and the website's choice of how to publish it. I guess I don't see why.
So here's
230 purposes.
Here's our test, and it's the test the Fourth Circuit recently took in Henderson, and it's the test the Ninth Circuit took. Let me give you an example that I think may help with the ad revenue sharing. So this was an allegation that YouTube was giving money to ISIS. Now, this was in connection with third-party videos, third-party information, but the court said, no, that is not within Section 230, because that's independent of the information, that's giving money to ISIS. That kind of, whatever you think about its validity under the statute, you're not treating them as a publisher, you're treating them as a financer. And it's just, and that's the test of the Fourth Circuit too. The Fourth Circuit is looking, in that case, it was about, all kinds of things were happening with third-party information, and they were trying to tease out, is it the credit report? Did they contribute to the credit report? Was it based on the website's failure to notify the employee? And what the Fourth Circuit said is the exact same thing we said, and it's the exact same thing the plaintiff has said on 4 pages of its brief, or 4 times in its brief, that you're looking for the harm. What is the harm caused? And this case is the perfect example. The plaintiffs suffered a terrible fate, and their argument is it's because people were radicalized by ISIS. And if you start with the concession that the dissemination of those ISIS videos and a claim based on that is barred, the question is what additional comes from the way it was organized? The government just says, I don't know, let some state figure it out. That's not very helpful to internets that have to work on a national level and are posting and sorting and organizing billions upon billions upon billions of pieces of information.
So just to clarify, this is my last point. You're happy with the Henderson test, the Fourth Circuit test?
Yes, I would say Henderson is like 96% correct. I got a little lost when they were going down the common law on publication, but the result was great. I just thought they got a little weird on the publication. But yeah, no, their test is correct. And it's also the Ninth Circuit's test on the ISIS revenue. It's the exact same test we quote in our brief, and it's the exact same test petitioner did. And what that harm test is doing, if I could just explain it, because it sounds kind of shorthand, but if you take which I'm not sure Justice Jackson agrees with, but if you take the underlying notion that this bars treatment as a publisher, and you're saying, well, can they get around it by the way they're pleading it? You're just looking to the harm. So you're saying you can't really say that's negligence or intentional affliction, because the harm is coming from the publishing of the defamatory content. And so what I think all these cases where the courts are correctly saying 230 does not apply to the claim is they're isolating the harm and saying that's independent of the third-party information. It's either based on the website's own speech or its website's own conduct that's independent of the harm flowing from the third-party information.
If YouTube labeled certain
videos.
Another thing I just thought of is I think it's important to take into account that basically these videos wouldn't exist on these platforms if these platforms didn't exist. So they definitely, in my opinion, do still have some liability, because you can't claim to have no liability when it's hosted. I mean, I'm not saying you should be liable necessarily for the content per se, like the content itself, but if people are claiming that they went down a rabbit hole because of your algorithm and the content was organized based off your algorithm, then I feel like you're liable.
Yeah, I could see that. I think they should be liable for like definitely stuff that's like illegal and just, legally speaking at least. And stuff that is like actively harmful. Like that actually can be proven to cause harm. And not just things that people find offensive.
Yeah.
Like I don't think they should be liable for like something that's offensive but not necessarily like tangibly harmful.
I mean, I agree with that, because that's going to be like, do I want to say discretionary? I don't know if that's right, but everyone's going to kind of have their own opinion of what is offensive and not offensive. But overall, I think a majority of people would agree that ISIS content is not good content that anybody would want to have on a streaming platform,
Yeah. I mean, I guess I personally see it like if ISIS is actively recruiting or they're like showing like beheading videos or something like that where it's like illegal or harmful like that, I think they should be accountable for that. But like if there's someone from ISIS and they're just like stating their opinions, I think that's different. Like even if they're really bad opinions, I think that's a little different than something that actively causes harm. But I don't think they should be paying ISIS though, even if they're
like they shouldn't get
be paid or getting enough views.
Whatever that thing is called, like when you can sign up when you have enough which is odd that they even qualified, because when you reach enough views and subscribers, you have to submit your request to become a partner to YouTube. So YouTube accepted ISIS and to get ad revenue. Like that was a choice that they made.
I wonder if a person even reviewed their request though. It could have just been like an AI or something that was reviewing that request.
Well, then clearly they need to work on that, because that's not an excuse to just be like, well, it was our AI that you're liable for that, because they were making money from you. That was a partnership in a way, because they were bringing money into you and you were paying them for that.
Yeah,
that's how the partnership works. So
I just think it's interesting with the AIs and like discriminatory AIs and stuff, because it kind of shows because with coding, they say like everybody codes differently, right? And so like the way that you would input information for the code to read might be discriminatory without you even knowing it. And it kind of just highlights like some of our societal problems and some problems in the way that the people coding this stuff are thinking.
Oh,
like subconsciously in a way.
Yeah, like when the algorithms.
Like I think there was a story with like Amazon where like they tried to have like an AI that would read applications, and like it ended up preferring like white candidates and like male candidates and stuff like that.
I think I've heard
so
of.
They had to like get rid of it.
I think I've heard of things like that. Yeah. And that's like
they've been talking about it too in these arguments a little bit. They've touched on that kind of stuff.
Yeah. And I think their biggest thing is, though, like the court, what they're trying to get across is that, like when they were bringing up like the dating and mixing, like not matching white people with black people or Hispanics with other people, like basically racist dating site, was that
Yeah.
the creators of the dating site made it that way.
Right. And whether it was intentional or not, they still made it that way.
Yes, and I guess that's pretty much sometimes what they're trying to determine with this whole thing is like YouTube's liability. Google's,
Yeah.
I guess, liability, because Google's the parent company, I guess. But
Yeah, I know this old CEO of YouTube stepped down, and there's been a new one recently. And the new CEO is the guy who wanted to like make YouTube videos into NFTs, basically.
oh, I
Which
didn't know
some
that.
YouTube videos are NFTs, but the company doesn't own them.
Oh yeah, want the person who, because then that would be their content. If they owned
Right,
it, then they would be liable for everything.
right.
If
But
they
he was trying
turned
to make
every
it so
video,
YouTube owned that content as an NFT.
well then they would be liable for all of it.
Yeah. Oh, that's
Like I don't
true.
think that would be a very good,
That would be a
like,
terrible decision.
yeah. Like I mean, like it sounds like good money wise, but that's not good for
Yeah.
you liability and legal wise. If you
Right.
want to maintain
That's true.
federal immunity, then you can't own any of the content. You're just supposed to let people post on your web. That's basically all that they should really do. In my, like, I get that the
Right.
algorithm helps get people's content out there, but I don't know. I still feel like the algorithm favors people over others still.
Yeah.
In my opinion, because it does. I
Oh
don't know.
yeah.
I don't really feel like it pushes out like newer content. I don't. I guess
Yeah,
I'm
like
not
smaller
really on YouTube.
creators.
Yeah, smaller creators, and I'm not really. I guess I don't really go scrolling on YouTube, so maybe it does. Maybe I'm wrong there, and that's
No,
fine.
I
I can
mean,
be
I
wrong, but
don't think it does very much, and I'm on YouTube like all the time. I think it mostly just promotes like the same content creators that are making them money.
yeah, and I mean, like I get it from a business point, but then also that is, in
But
my
then they are
opinion, you're doing
choosing to
that.
push
That's
certain
your.
content, and they
Hmm?
should be liable for that.
Yes, I personally think so. And so, like I don't know. I definitely think they're responsible for their algorithm, because algorithms don't just pop up out of thin air. You like,
Right.
I mean, even if it's like what is that, machine learning, where you like feed it stuff and then it
Yeah.
learns, like you are still feeding it stuff. Like it would not
Yeah, and it's still
exist
programmed a
without
certain
you
way.
creating it.
Yeah, it's still
So
programmed a
you do
certain
not
way.
get to claim ignorance
Right.
when you are the company that created it, you know?
Yeah. No, I totally agree.
We'll keep going.
As the product of what it labels as responsible news providers. That would be Google's own content, right?
Yes. Yes. And yes.
Yeah.
Can I say one thing? Just because I
Yeah,
forgot to mention
sure.
thumbnails. Sorry. Thumbnails aren't mentioned in the complaint. So I was literally trying to figure out what he was talking about when I was up there, because it's just not something in the complaint. But that is a screenshot of the information being provided by another. It's the embedded third-party speech. Okay. Sorry. Keep
All
going.
right. So if I do a search for today's news in YouTube, in fact, I did that yesterday, and all the top hits were very well-known news sources. Those are not recommendations. That's not YouTube speech. The fact that YouTube put those at the top, so those are the ones I'm most likely to look at. That's not YouTube speech.
Right. But I mean, all search engines work the same way. If you type in whatever you type in, there is a algorithm that's deciding what content to display. It has to be displayed somehow. And what I think is going on YouTube, or it's certainly going on Google search, is they're looking at, well, what did other users look? How popular was it? that kind of thing. Is that news source, from Russia? Probably not going to get on the top list. So yeah, they're having to make choices because there could be over 1 billion hits from yours. And there are a billion hours of videos watched each day on YouTube and 500 hours uploaded every minute. So it's a lot of content on YouTube. So some of it's based on channels and some of it's based on searches, but they have to organize it somehow. But that is what's going on, I think, on your top searches. Is they're and most search engines too, and you can look at the Microsoft brief. They're basing it on what time spent on those news sites, how many users are looking at them, how relevant it is. If you're typing in the Turkey earthquake, they might be elevating some stuff that's featuring that because it's seems more relevant. If there's a recent election, they might feature that. So all these kinds of decisions are being made by websites every day.
Would Google collapse and the internet be destroyed if YouTube and therefore Google were potentially liable for posting and refusing to take down videos that it knows are defamatory and false?
Well, I don't think Google would. I think probably every other website might be because they're not as big as Google. But here's what happens. I mean, you do have that situation in Europe, but there's not class actions. There's not plaintiffs' lawyers. There's just not the tort system. So what you would have is a deluge of people saying, that restaurant review was, you said my restaurant review, I didn't like it. I think Yelp does an amazing job on this about how much they got hit and had to spend, almost crushing litigation because they were being accused of being, biased on reviewers, and everyone, no matter what, they couldn't win for losing or lose for winning, whatever the phrase is, because whoever got reviewed, somebody was upset. And so I think those websites, they never would have happened and they probably would collapse.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Kagan? Justice Gorsuch?
Ms. Blatt, I kind of want to return to some of the questions I asked earlier. It seems to me inherent in C1 is a distinction between those who are simply interactive computer services and those who are information content providers. And so when we flip over to F, the distinction I glean from that is that if you're picking, choosing, analyzing, or digesting content, which is the bulk of what how you describe Google's activities in a search engine context, are protected, and that content must be something more than that. Providing content must be something more than that. Is that right, in your view?
I thought you were absolutely correct, and I think some of the amicus briefs do this in terms of if you're looking at what is information being created or developed, there is that distinction. It can't be that by sorting, you created or partially developed the information. So I think you had it exactly right. I got a little upset when you talked about a remand that somehow the Ninth Circuit got it wrong.
Well, let's go there next then, because it seems to me that even under that understanding of the statute, there is some residual content for which an interactive computer service can be liable. You'd agree with that that's possible?
Not on this complaint, because
No, of course not on this complaint, but in the abstract, it's
absolutely
possible.
Correct.
Okay. And then when it comes to what the Ninth Circuit did, it applied this neutral tools test. And I guess my problem with that is that language isn't anywhere in the statute, number one. Number two, you can use algorithms as well as persons to generate content. So just because it's an algorithm doesn't mean it can't generate content, it seems to me. And third, that I'm not even sure any algorithm really is neutral. I'm not even sure what that test means, because most algorithms are designed these days to maximize profits. There are other examples. Justice Kagan offered some. The Solicitor General offered some where an algorithm might contain a point of view, even a discriminatory one. So I guess I'm not sure I understand why the Ninth Circuit's test was the appropriate one and why a remand wouldn't be appropriate to have it applied, the test that we just discussed.
Because it's not, I don't think that was the Ninth Circuit's test. It was one sentence that was, maybe I think it mentioned it twice. It's basically, almost making fun of the complaint. The complaint doesn't.
Okay. So we're just disagreeing over how we read the Ninth Circuit's opinion. But if I read it that way, then would a remand be appropriate?
Well, I'm going to say no, because I don't understand how somehow that they have a bad complaint means the Ninth Circuit's worse off. When the Ninth Circuit said over and over and over, this is just the way you're organizing it. And the complaint never alleges there was something independently wrongful about the content. It never says these were colloquial recommendations. It just says because you previously liked this content. And one other thing, the complaint never even alleges that the YouTube ever recommended to even in terms of even displaying an ISIS video to anybody who wasn't looking for it. I don't even know how you could get ISIS on your YouTube system unless you were searching for it. And
I certainly understand your complaints about the complaint. But if you don't think neutral tools, you're not defending the neutral tools principle either, as I understand it.
I'm defending it with respect to Justice Kagan's question, absolutely, because she's concerned about biased algorithms, and she doesn't have to worry about that in this case because they have neutral algorithms. They don't allege, and what they mean by neutral algorithms is neutral with respect to content. So there's
Thank you.
Okay.
Thank you.
Thank you.
Justice Kavanaugh? No? Justice Barrett? Justice Jackson?
So I understood you to say that 230 immunizes platforms for treatment as a publisher, which you take to mean if they are acting as a publisher in the sense that they're organizing and editing and not editing, but organizing and content.
Communicating, broadcasting, which includes how it's displayed.
And would that include, I just want to go back to Justice Alito's point, would that include the homepage of the YouTube website that has a featured video box, and the featured video is the ISIS video? That
Right.
is covered.
Well, maybe not, because that gets into my continuum question. If you think that featured is some sort of endorsement such that the claim is actually treating the website as, and that the harm is flowing from the word feature, then that's out of 230. I think you would.
No, I'm sorry, why? Why is that out of 230?
So the whole point about what we're saying is making sure that if you start with the assumption that the dissemination of of ISIS videos, you can't hold the YouTube liable for that, then the only question that we're concerned about, and which is so destabilizing, is if you can just plead around it by pointing to anything inherent in the publication. And the government never said what websites are supposed to do.
No, but this is not inherent in the public.
Exactly, it's featured.
So this is helpful. I mean, if we have a home page on YouTube, and it has featured as the little title and a box. And let's say the algorithm randomly selects videos from their content and it puts them up for a week at a time. And the random video that's selected is the ISIS video. And it runs when you open up YouTube for a week.
Right.
Covered or not covered?
Well, it depends on whether you think it's an endorsement of, if it said, this is the Library of Congress and we feature this because we want to show you how bad ISIS is, I don't know. The reason why I care so much about this is because, like I said, Google and YouTube don't do this, but all the other amicus briefs are talking about they do things like that, and they might have a little emoji.
I guess I'm just trying, I don't understand. I just want to know whether the putting on the homepage of YouTube, the decision to have an algorithm that puts on its homepage various videos, third-party content, and it turns out that one of those videos is an ISIS video and the person is radicalized and they harm the petitioner's family.
Yes, so that is inherent to publishing the homepage. The word feature, actually using the express statement of feature, it's not, the website didn't have to do it.
So I'm sorry, inherent to publishing, it's
the
covered?
homepage.
It's covered.
Absolutely, because no website, how are you supposed to operate a website unless you put a homepage on? And so they have to do something. And if you could always say, well, the homepage, unless you're just going to do it alphabetically or reverse chronological order, a website is always going to be sued for negligence.
All right. So if I disagree with you and I'm about the meaning of the statute, all right, focusing in on the meaning of the statute, you say if you're making editorial judgments about how to organize things, then you're a publisher and you're covered. If I think that the statute really only provides immunity if the claim is that the platform has this ISIS video there and it can be accessed and it hasn't taken it down. Do you have an argument that the recommendations that they're talking about is tantamount to the same thing?
Yes, because the only basis for saying recommendations are not covered is that I saw as the government saying is it conveys a distinct implicit message that you might be interested. That is a distinct implicit message that can only, it happens every time you publish. If you publish one thing on the internet, it conveys a distinct message of, dear reader, we sat around and thought you might be interested, or we want to make money.
You're saying that there's no, that organizational choices that put that content on the front page, on the first thing when you open it up without typing in anything, cannot be isolated, and that it's the same thing as it appears on the internet anywhere, such that 230 applies.
Yeah, yes, and I'll use the government's own words. They said if you hold them liable for topic headings, you render the statute a dead letter because you have to organize the content. So if you think the topic headings are conveying some implicit message you can target out, the government said then the web can't function. And I think we care about it because we're big websites that have lots of information. Other websites and all the amici briefs are saying is our whole business is organizing to make it useful. If you need a job, you're going to organize it by location.
Are you aware of any defamation claim in any state or jurisdiction in which you would be held liable, you would actually be liable for organizational choices like this?
No, I'm not worried about the defamation claim. I'm worried for a products liability claim, or what the government kept saying, your design choices. Those could just be a product liability claim or a negligence claim. You negligently went in alphabetical, or you negligently featured whatever you featured that made my, kid addicted to whatever it was. And those kind of claims happen because they're publishing. And the whole point of getting the statute was to protect against publishing. So whatever is publishing, inherent to publishing, has to be covered.
Thank you.
Thank you, counsel. Rebuttal, Mr. Schnapper.
Thank you. Mr. Chief Justice, may it please the court. If I might start with my colleague's reference to things inherent in publishing. I would just offer a cautionary note, and a review of the transcript will support this. That has been given an extraordinarily expansive account here. So topic headings were characterized as inherent in publishing. Again, a topic heading could be how Bob steals things all the time. Shouldn't be protected. She mentioned trending now as inherent in publishing, but that's like featured today. You could have a site that didn't use the words trending now. Autoplay certainly isn't inherent in publication. And she mentioned homepages, and you have to have a homepage, and that's fair. But you don't have to have on the homepage selected things that you're drawing people's attention to. The homepage that I have on my desktop for Google is a box and those charming little cartoons, and there isn't anything featured there. One could have a website homepage for YouTube that wasn't promoting particular things. That's just how they've chosen to do it. With regard to neutral tools, and this goes back to the point a number of you made about race, a neutral algorithm can end up creating very non-neutral rules. It's not hard to imagine that an algorithm might conclude that most people who went to Spelman and Morehouse now live in Prince George's County. And therefore, in showing you videos, people who ask for videos about places to live near Washington, if they're black, they'll be shown Prince George's County. If they're white, they'll be shown Montgomery County. Algorithms can create those kinds of rules. Whether characterizing that as neutral loses its force once the defendant knows it's happening. To some extent, algorithms and computer functions can run amok, but you can't call it neutral once the defendant knows that its algorithm is doing that. And this runs a little bit into the issue that we'll be talking about tomorrow. Two short points and then one closing item. With regard to rule section F4, I said this before, I just want to reiterate it. Section F4 does not apply to systems or to information services. It only applies to software providers. The language of the statute is very specific. And with a question about the possible implications of the decision in TAMNA, it is normal practice in the district court when there's a motion to dismiss to permit the plaintiff to amend to deal with the relevant standard, and that's exactly what we ought to be and afforded an opportunity to do. Thank you very much.
Thank you, counsel. The case is submitted.
Cool.
Whoa, where did? Okay. So that was Gonzalez versus Google. And yeah, it'll be interesting to see what comes out of it. You're curious what?
How they're gonna vote on it.
Yeah, that'll be.
Who's gonna vote for what?
And we'll definitely have to listen. Let me see. And not
I
obviously
might actually
tonight,
agree with
but
Brent tapping on something.
how long is the Twitter? 2.5. So about the same length. So we'll have to give that one a listen before. I don't think I think June is when they'll release their.
Yeah.
And then I still want to listen to the student loan. I mean, we don't have to do that live if we don't want to, but I definitely want to give those a listen. And
yeah, I do want to go back and listen to the old one with Roe v. Wade. What was it called? Jackson, right?
Dobbs
versus
yeah, because we had to look that
Health
up.
or
Yeah, because I forgot. But yeah, it'll be interesting to see what comes out of all this, and then there's also the Morvey Harper too. That'll be interesting to see.
Yeah,
that one I don't know too much about. I mean, we could also.
Which one is that again?
It has. Let me just.
There's so many cases I get confused.
So, Morvey Harper is an ongoing United States Supreme Court case related to the independent state legislature theory arising from the redistricting of North Carolina's districts by the North Carolina legislature following the 2020 census, which the state courts found to be too artificial and partisan, and an extreme case of gerrymandering in favor of the Republican Party.
That is what it sounds like.
So we'll kind of have to see what comes out of that one too.
Yes. Tomorrow we'll play Jackbox.
Yes, yeah. And then I think next weekend we might listen to another.
Okay.
Or we don't have to, but
yeah, we'll figure something out.
For sure tomorrow will be like gaming, chill.
Yeah.
Jackbox. But yeah, otherwise I think that's it for now. So join us tomorrow if you want to hang out and just play Jackbox for a little bit. We'll have it set up on the screen, and then we'll have it set up so people should be able to join us. But otherwise, thanks for watching, and we'll see you next time.